Welcome, Beresford Booth fans. I'm Andrew McKenzie, one of the partners here, and I have been handling real estate transactions and litigation for over 19 years, including in Washington State and California. Today, I will be discussing a fun and lesser-known tool for subdividing land in Washington State. More specifically, I'll be talking about Testamentary Subdivision, a method to subdivide property when it transfers through a will or inheritance. But before we delve in, don't forget to subscribe to our YouTube channel, where you can find highly valuable information on tons of legal topics, from family law to real estate, business, litigation, estate planning, and probate. Our firm has helped individuals and small businesses achieve their goals since 1946. Remember, this video does not constitute legal advice. Your specific situation will require consultation with a lawyer who can analyze your individual circumstances. Now let's get into it. First, what is subdividing property? We're going to talk a little bit about what subdivision is and why it's important. In Washington, like most places, the right to develop property is usually tied to identifiable tax parcels. Each parcel will have a zoning designation, typically governing what can be built or what legal uses can occur on that parcel. The zoning will usually specify the minimum and maximum density of that parcel, such as the number of residential units allowed per parcel or the minimum lot size. Especially in the case of single-family homes, zoning laws for residential areas typically only allow one single-family home per lot. Subdivision regulations go hand in hand with zoning, which is considered part of the government's police powers. In theory, these regulations protect the public by improving property values, ensuring efficient and orderly use of land, and preventing overuse of public resources like roads, parks, schools, utilities, and other infrastructure. Subdivision also plays an important role in establishing property ownership rights. Rather than have multiple owners co-own a larger parcel, which can blur the lines of who has what property rights, subdivision allows smaller parcels to be separately owned outright, segregating control of the property in neatly defined pieces. What does the normal subdivision process look like in Washington? In addition to some local regulations, state law normally requires an owner to apply to the local jurisdiction for subdivision approval. Normally, once you apply for subdivision approval with a complete application, you benefit from the land use laws in effect at that time, meaning that if stricter regulations come along later, they may not apply to your subdivision process. Most of the time, the applicant must obtain a survey of the property to submit with the application. The survey will typically include a map with the proposed new parcels and their legal boundaries, often referred to as a plat map. The applicant will also have to place survey monuments at the corners of the property being subdivided. The application will normally need to show that each new parcel will have appropriate access and will not envision development in environmentally sensitive areas. The local jurisdiction will review the application and set a public hearing and normally give notice to adjacent landowners. Assuming that the local jurisdiction determines that the proposed subdivision complies with applicable land use regulations, it will ordinarily grant preliminary approval of the subdivision, which will include conditions for the subdivision to become final, such as the installation of infrastructure required. Once the subdividing party completes that infrastructure, the local jurisdiction will issue a final approval, at which point the newly created parcels are now fully legal and may be separately transferred. For anyone who has gone through the subdivision process lately, they will already know how cumbersome it tends to be. Subdivisions can literally take years for approval because of the level of regulation and bureaucracy associated with them. The process can also be costly. RCW 58.17 is the general chapter of state law governing subdivisions, and it normally mandates subdividing property through an application with the local jurisdiction. However, RCW 58.17.040 subsection 3 contains an exception stating the provisions of this chapter shall not apply to divisions made by testamentary provisions or the laws of descent. So how can you utilize this exception? Ideally, you should state expressly in your will your intention to subdivide your property upon your death. But some case law allows heirs to agree to a subdivision so long as those heirs collectively own the entirety of the property. In one case in San Juan County, the testator left property to 3 heirs who tried to use the testamentary subdivision exception to divide the property into 3 parcels. The county took the position that in order to use the exception, the will had to specifically divide the property into discrete identifiable parcels. The Court of Appeals rejected this argument, stating, "A will need not subdivide the property into separate parcels, but a division of the property by those taking under a residuary clause may be made without complying with the short plat requirements." The court relied upon the phrase in the statute or the laws of descent as being broader than the phrase testamentary provisions, and therefore there need not be an expressed intent to subdivide laid out in the will. What interest needs to be conveyed to the heirs? The whole enchilada. Washington precedent says that the heirs must receive the entirety. In one case, the decedent owned only a 25% interest in a 10-acre parcel. The will transferred this 25% interest into a trust for her 5 children at her death, with the title to be transferred directly to the children when the youngest child reached age 30. By the time that happened, the children had acquired title to the remaining 75% of the property, and they argued that they could then use the testamentary subdivision exception to subdivide. The Court of Appeals rejected this argument, holding you cannot subdivide under the statutory exception where the heirs did not receive the entirety of the property through inheritance. Stated another way, testamentary subdivision does not extend to mere partial interests in property. One lesson from this case is that the decedent should ideally acquire the entirety of the property before planning on using the testamentary subdivision exception. With this principle in mind, spouses should be especially careful in not creating divided interests in their wills if they want to take advantage of a testamentary subdivision. Testamentary subdivisions, while a convenient tool, also have significant regulatory limitations. In one case, the testator conveyed land in Skagit County into a trust at their death, dividing a 15-acre parcel into 7 lots. The trustees of the trust then tried to develop the lots, but the county denied the permit applications because the property was located in an agricultural zone with 40-acre minimum lot sizes. Although the Court of Appeals recognized that the lots were legal lots, the court held that the county was not obligated to issue building permits because of the zoning violations. These were considered non-conforming or substandard lots. So what are the requirements for a lot created through testamentary subdivision for it to be buildable? While there is not a single universal answer, generally speaking, most local jurisdictions require that 1, the newly created lot has to meet the minimum lot size for the applicable zoning. For example, if the minimum lot size is 1 acre, don't plan on being able to build a bunch of newly created 1/4 acre lots. Second, the lot has to have appropriate access to meet the normal requirements in effect at the time that the lot was created. Third, the developer must still comply with applicable environmental regulations, setbacks, etc. For example, if land is not buildable because it lies within a wetland, it doesn't get rendered buildable just because new lots were created within the wetland. Here's a really cool trick. In some cases, it may be possible to use a testamentary subdivision, which creates a substandard or non-conforming lot, but without creating a buildability problem. So look at this illustration that I have here on the slide. Suppose that you had a 12-acre parcel with an existing house on it in a zone with a minimum 5-acre lot size. It may be possible to divide that property into 3 lots consisting of 2 vacant 5-acre lots and 1 non-conforming 2-acre lot, which contains the existing house. Because the house is already existing, there should not be a building permit problem to maintain it. But the other 5-acre lots would be fully conforming, allowing them to be developed with new homes. Under such a hypothetical, in the absence of a testamentary subdivision, one would ordinarily only be able to create one new building lot rather than two. Therefore, careful planning and strategizing can maximize the property value for one's heirs. In conclusion, families with potentially subdividable land looking to maximize property value at the time of inheritance should give serious consideration to testamentary subdivision. Our firm has significant experience both in real estate matters and in estate planning. We would love to assist you. Give us a call at 425-776-4100 or shoot me an email at andrewm@beresfordlaw.com. Thanks for watching.